Welcome to another special edition of COS Live. This is our second special broadcast of the day. I'm your host, Rita Peters. I'm the Senior Vice President for Legislative Affairs with Convention of States Action. And in just a little while, we are expecting the Montana Senate to debate and vote on our Article 5 resolution calling for a convention of states. You will hear it referred to in the Montana Senate as SJ2. It is Senate Joint Resolution 2. 19 states have already passed our resolution calling for an Article 5 convention for proposing amendments to the U.S. Constitution on three topics: fiscal restraints, term limits, and limits on federal scope and jurisdiction. We need 34 states to get to convention, so just 15 to go to call the first ever Article 5 convention. Currently, there are 12 states that have introduced our resolution in 2023, with more expected. So far, we have Illinois, Iowa, Massachusetts, Minnesota, Montana, New Hampshire, New Mexico, New York, Rhode Island, Virginia, Washington, and Wyoming. All have active legislation based on our model language limited to those three subject matters I mentioned earlier. And actually, breaking news just today, Vermont has now introduced the resolution as well. So 13 states now have legislation pending. How did we get to this point in Montana? Well, the Convention of States Montana volunteer team has been busy building support across the state and in the legislature. Over 16,000 Montanans have signed the Convention of States petition asking their state legislators to vote yes for COS. Our resolution has been championed there in Montana by Senator Tom McGilvery. He's hosted several town halls across the state over the past couple of years. Hundreds of locals have shown up to these Convention of States town halls, sometimes headlined by COS Action's senior advisor Rick Santorum or Senator McGilvery's friend, Article 5 scholar Robert G. Nadelson. Now, fast forward to just a couple of weeks ago, the Montana Senate Committee on Business, Labor, and Economic Affairs heard 3 hours of testimony on Convention of States, and they later voted 6-4 to advance our resolution on to the full Montana Senate. If we have a successful vote today, there's one more technical requirement for a third reading. Bills and resolutions in Montana are required to have 3 readings, but that third reading is simply a technicality. So today's the big step to ensure that we get to go over to the Montana House for final passage of our resolution. It's an important day today in Montana. After the vote, we will have a recap, and then we'll get live reaction from Convention of States Action Senior Regional Director David Schneider. Montana is one of the states in Dave's region. Now, there are 6 bills ahead of us on the calendar today in the Montana Senate. Of course, we never know exactly how long these bills are going to take, depending on the subject matter. They could be really quick, or they could be bills that involve a lot of debate and consideration before the vote. So the Montana Senate is getting started now. Again, we have 6 bills ahead of us. Not quite sure how long they will take, but stay right here because we will be coming back to let you know when they get close. So when they get on the bill that we're expected to go before us, we'll come back and let you know. We might even pop on with a few updates or just to check in before we get to our resolution. And again, our resolution in the Montana Senate is SJ2, Senate Joint Resolution 2. So stay tuned. It's going to be exciting. It's always fun to watch and listen to our state legislative bodies as they are in action. I never find a dull moment, actually. It's so interesting to see what our state legislatures are doing. So with that, we're going to go ahead and take you to the live stream of the Montana Senate.
want the people that are here supporting Convention of States to stand. They're here and going to watch the floor debate today. So thank you for being here. If you'd stand up, Convention of States people, that'd be great.
Welcome to the Senate. Senator Gillespie.
Mr. President, I'd like to be off the record and out of the journal for a quick advisement here. There are donuts next door here, and I had a slight phone malfunction yesterday. Wasn't my fault, of course, but and I thought I was going to get away with it, but the senator to my left here started laughing and smacking his lips, so I knew I was busted. So anyway, enjoy the sweets. And remember, I do have some really good bills coming up in the next 2 weeks, so keep savor the moment. Thank you.
Okay, that objection will be on order of business number 7, second reading of bills. Mr. Majority Leader.
Mr. President, I move the Senate resolve itself into the Committee of the Whole for the purpose of consideration of business on second reading.
You've heard the motion of Senator Fitzpatrick. All those in favor say aye. Those opposed, no. Ayes have it. Mr. Majority Leader.
Mr. President, I move to pass Senate Bill 171 for the day.
That objection so ordered. Members, you now have before you for your consideration Senate Bill 57. The clerk will read the title and history of the bill.
Senate Bill 57, introduced by Manzella by request of the Department of Transportation, a bill for an act entitled Act generally revising Department of Transportation contracting, providing for alternative project delivery methods, revising termination dates regarding alternative project delivery, amending sections, and providing an immediate effective date.
Are there any corrections to the history and title of the bill as read?
None, Mr. President.
Clerk will read the sections.
1 through 10.
Members of the committee, you now have before you Senate Bill 57. What is your pleasure, Senator Manzella?
Mr. Chair, I move that when this committee does rise and report after having had under consideration Senate Bill 57, that it recommend the same do pass.
Senator Manzella.
Mr. Chair, members of the Senate, I bring you Senate Bill 57 at the request of the Department of Transportation, which is a bill, an act generally revising Department of Transportation contracting, providing for alternative project delivery methods. And in Montana, that means we're adding 2 additional contracting and delivery methods to the process that we already have in place. Basically, it gives the Department of Transportation 2 more tools in their toolbox to deliver on contracts and the work that we hire them to do. What the bill does, the bill authorizes the Montana Transportation Commission to award projects using all alternative project delivery methods approved by the Federal Highway Administration upon recommendation of the department. It consolidates the Commission's contracting authority under Title 60, Chapter 2, Part 1 of the MCA. The term alternative project delivery methods applies only to MDT and the Commission. Similarly, Title 18, Chapter 2, Part 1 authorizes state agencies other than the MDT and the Commission to enter specific types of alternative delivery projects, alternative project delivery contracts. Design build is excluded from the definition of alternative project delivery methods, as the Commission's authority to award design build contracts is codified in 60-2-111. It basically, again, it simply gives the department 2 more opportunities and 2 more different methods, one called design build and the second one called progressive design build, for contracting on jobs that we're asking them to do. Please give it a do pass.
Are there any amendments?
None, Mr. President.
Is there discussion on the motion? Seeing none, Senator, would you care to close? Senator has closed. The question now rises on the motion of Senator Manzella that when this committee does rise and report having under consideration Senate Bill 57, it recommends same do pass. As many of those in favor signify by voting aye. Those opposed vote no. Has every member voted? Does any member wish to change his or her vote? The clerk will record the vote.
Mr. President, 50 senators vote aye.
50 senators having voted aye. Senate Bill 57 has passed second reading. Members, you now have before you for your consideration Senate Bill 160. The clerk will read the title and history of the bill.
Senate Bill 160, introduced by Molnar and others, a bill for an act entitled Act Generally Revising Laws Related to Drug or Human Trafficking, providing a reward for information leading to the conviction of drug or human traffickers, requiring a sign proclaiming a reward at all ports of entry, airports, railway stations, and bus stations, exempting the reward from taxation and providing an effective date.
Are there any corrections to the title and history of the bill as read?
None, Mr. President.
Clerk will read the sections.
1 through 4.
Members of the committee, you now have before you Senate Bill 160. What is your pleasure, Senator Molnar?
Mr. President, I move that when this committee does rise and report after having it under consideration Senate Bill 160, that it recommend the same do pass. Mr. President.
Senator Molnar.
Thank you. Those of you that were here last session may remember this bill. It came out of judiciary last session unanimously, came second reading where we're at today. It was 45-5. It's not the most controversial bill in the world. It's just new. It's a new concept. Came out of judiciary here, I think, with 2 no votes. So what does it do? It establishes a reward for the arrest and conviction of somebody dealing drugs, Schedule 1 or Schedule 2, in an amount greater than personal use. We're looking at dealers. This does not pick up street kids with a problem. It picks up the people that give street kids a problem. It gives a way for somebody that is caught up in human trafficking. Maybe it's just a phone number in a bus depot. They can call for help to get out. If they want the reward, and if it's an actionable tip, then they get the reward. Now, some of this, I'm going to explain this fairly quickly. It's pretty easy to read. If there's any questions, of course, I'm more than willing to stand for those. But in explaining the amendments that were put on in committee, which were drafted by me, I think there's a lot of understanding that can be gathered. The amendment on line 11, which is the whereases, adds fentanyl and heroin at the request of Representative Windy Boy to draw attention to the plight of residents on the various reservations. Of course, the drug plague is in every corner of our state and in all states. Section 2 creates the reward for $50,000 for actionable, which is another amendment, information leading to the conviction of those that traffic in drugs in an amount of excess of $10,000, which in my county, and my county attorney handles more drug cases than any other in the state, is considered the amount to be for sale and not personal use. And those are the only ones he's really concerned about prosecuting. This amount is per my county attorney. When I started working on this concept about 2.5 years ago, meth was $800 per ounce. Now it is $250 to $500 per ounce, depending on quality. Heroin was $350 to $400 per gram. Now it is $200 per gram and includes fentanyl for that price. Doesn't include fentanyl? It's cheaper. And fentanyl, 2.5 years ago, was $30 to $40 per pill. Now it is $20 to $30 per pill. This is market evidence that it is a very competitive market. Quality is up, price is down. I'm told that in Butte, no slam intended, during the same time frame, all prices were lower because it's far more accessible. It now takes far more drugs in possession to trigger the reward created in 160, and that's only in 2 years. They have to have a lot more. That means a lot more is coming in. Senate Bill 160, page 2, line 9, plainly states that the identity of the informant is not to be known. Yet, some of my opponents argue that this testimony will cause juror backlash because they received money. I am not sure how you can subpoena someone that you don't know the identity of, because the call center is a black box. You don't know who's calling. So the amendment on page 2, line 22-23, strengthens that the tactics used during the investigation will strive to protect the informant. Our Board of Crime Control has almost 24 undercover DEA agents. The DEA has, we don't know how many in the state. Our sheriffs and our police know how to run an investigation and not burn their informant. The reason I put that in there was so that other people reading it, wondering Do I want to make this call? Can I stay confidential? It gives them assurance that we're going to do the best we can. And of course, if their name has to be given, they have a right to say no, and they don't get the reward. I'm going to go quickly to the fiscal notes. I'm just about done. Note that the size of the signs, the large ones, cost $20,000 per sign. I think that's a little high. $17,000 for the small signs. It says that it's such a big deal they're going to have to contract it out. I was told by somebody who understands Section D of the budget that if I put a budget in here, or an amendment that says that the current maintenance funds will be used, that goes away. Our prisoners make the signs. If they're that busy, they can put the pheasant feeders on automatic discharge and they'll have time to go make some signs. 2 FTEs, page 3, line 11, doing what? Until June, the bill doesn't become effective. Then they start making signs. Then they got to get them up and somebody has to call. I'm not sure what these guys are going to be doing. I may have to apply for the job to find out. Page 3, number 3, 75 rewards is what they're saying. We'll have an additional 75 convictions if we put up the signs offering the reward. That's 1 per week and 2 every other week for a year. Once we start getting press that the rewards are working, those reliant on the code of trust amongst drug dealers and human traffickers hopefully will take Montana off their distribution plan, and that's the intent of the bill. I don't want to be arresting people. I don't want to feed them. So it's to give them cause about coming to Montana. Go to Wyoming, sell your drugs, go to the park, go home. Don't come north. Page 3, line 20. Those that operate at the possession limit are required to trigger the reward are well above the street dealer, so will not need to rely on the Office of Public Defender. A, they have money. B, not to mention, most if not all of these cases will go to federal court because it's above possession. You're into distribution charges. And we will not be funding their defense or their incarceration. The call center, which is the question that came up, can easily be another phone at the Montana Highway Patrol dispatch desk. When it rings, you answer reward center, however you want to answer it, and you take the information, you set up a black box, you can communicate to them through that, and you can distribute the funds. This is not particularly unique. We have Tipmont for those that poach. We have Crime Stoppers in Billings, very successful. I don't mean to lose Senator Lenz on this, but DPPHS has a confidential call line. And there's quite a few at the federal level for whistleblowers. Why do we do it? Because it works. I will, of course, yield to any and all questions, sir.
Are there any amendments?
None, Mr. President.
Is there discussion on the motion? Seeing none, will the senator care to close?
Mr. President, I would. Last time I sang my close, I think I'm going to forego that this time. I close.
Question now arises on the motion of Senator Molnar when this committee does rise and report having under consideration Senate Bill 160, recommend the same do pass. Many of those in favor of the motion signify by voting aye. Those opposed vote no. Has every member voted? Senator Escher, does any member wish to change his or her vote? The clerk will record the votes.
Mr. President, 44 senators vote aye and 6 senators vote nay.
44 senators having voted aye, 6 voting nay. Senate Bill 160 has passed second reading. Members, you now have before you for your consideration Senate Bill 183. The clerk will read the title and history of the bill.
Senate Bill 183, introduced by Lentz, a bill for an act entitled an act providing for jury trials in cases involving the termination of parental rights and amending sections.
Are there any corrections to the history and title of the bill as read?
None, Mr. President.
Clerk will read the sections.
1 through 8.
Members of the committee, you now have before you Senate Bill 183. What is your pleasure, Senator Lenz?
Mr. President, I move that when this committee does rise and report after having had under consideration Senate Bill 183, it recommend the same do pass, Mr. President.
Senator Lenz.
Members of the body, come before you with a bill that reflects how we may be starting to look at CPS cases in Montana. it has been, CPS cases are always difficult. There is a criminal side and a civil side. They entwine at certain points. There are advantages within the civil parameter. If you don't have your act together, you need to go through drug treatment, you need parenting classes, whatever it is that you need to get your act together, that can be operated in the civil side. If you have overstepped your bounds on the criminal side, abused, then the criminal will address that. But when we come to the point of having to terminate parental rights, that's a sad moment. It's a difficult moment. Maybe, and I suspect strongly there are some parents who don't even understand the point of that at that moment. They may not get it. They may not understand, but there are many, many within the system. And the system has parameters it operates under. The federal guidelines are 15 out of 22 months if the child has been away from the parents, that you can move with parental termination. Well, sometimes it takes a parent to get their head around the fact that they don't have their act together. And they may not meet that guideline. They may be lagging. They may be moving forward in the system. And so what Senate Bill 183 does is provide for a jury trial for parental termination if the parent wants it. I think it says in the fiscal note they estimated possibly 16 trials per year. I know I was just on a jury in Billings for a sexual assault that they called in 200 members for that jury pool. I can't imagine it being that deep for a parental termination, but that could be up to the judges. And so what I'm causing, and I'll be glad to talk about it and glad to answer any questions, is to cause a pause at that last threshold before we step over and rights are terminated, that we have the public's ability to step in, not just a single judge, but the community can step in and say, is this right or is this wrong? And with that, I look forward to the discussion, Mr. President.
Are there any amendments?
None, Mr. President.
To discussion on the motion, Senator Olson.
Thank you, Mr. President. Colleagues, this is probably a very difficult bill to discuss. We all understand that we have a constitutional right to a jury trial in most cases, and that's a really important right. But I do think for me, and for the system, this has been balanced in Montana against the right of privacy. So when you have dependency and neglect cases, the names of the children are always secured as initials so as to maintain their privacy. So what we're really looking at is if we have a jury trial, this does go against the privacy of the children in the sense that it's very difficult to keep private what you've aired in a jury. And for those reasons, I think it's a difficult decision, but that's the reason that I'll be a no on this bill. Thank you.
Is there any other discussion? Senator Emmerich.
Thank you, members of the body. I want to speak on this bill for simple fact is I was actually in the committee as a good senator across the aisle, and I think that it is very important that we do offer jury trials for the termination of parental rights because it is a right. It is a constitutional right. Your parental rights are protected. And if we are looking at terminating those rights, that's a very, very big thing to do. So offering a jury trial mitigates a lot of concerns of parents in these cases. We heard a lot of testimony that there wasn't a large number of cases that this would affect. But the ones that it would affect typically are the cases where the parents aren't under the impression that they are receiving proper adjudication, that they are not receiving they may not receive justice under a judge. So having them have the ability to be able to be judged by a jury of their peers will better satisfy their constitutional right in a jury trial, and therefore maybe make them more accepting if they do terminate their rights, that they did have a fair trial.
Seeing no further discussion, Senator, would you care to close?
Thank you, Mr. President. I would just like to highlight on page 2, lines 21, where it says no jury trial would be allowed for this. That seems odd, given our legal system. It seems quite odd to me. I respect the comments from the good senator from Missoula. But at this point, how private is it? This has been a difficult thing that's gone on for years within the community. And at the last stage, let's give them an opportunity to make their case before a jury. And I appreciate your consideration, Mr. President.
Question now arises on the motion of Senator Lenz that when this committee does rise and report having under consideration Senate Bill 183, we recommend the same do pass. As many of those in favor signify by voting aye. Those opposed vote no. Has every member voted? Senator Morgeau, does any member wish to change his or her vote? The clerk will record the votes.
Mr. President, 36 senators vote aye and 14 senators vote nay.
36 senators have voted aye, 14 have voted nay. Senate Bill 183 has passed second reading. Members, you now have before you for your consideration Senate Bill 184. The clerk will read the title and history of the bill.
Senate Bill 184, introduced by Lentz, a bill for an act entitled Act revising procedural requirements in child abuse and neglect proceedings prohibiting transfers of venue outside of the county in which an abuse and neglect petition was filed, providing exceptions to the prohibition of transfers of venue, prohibiting continuances of hearings unless exigent circumstances exist, defining exigent circumstances, and amending sections.
Are there any corrections to the history and title of the bill as read?
None, Mr. President.
Clerk will read the sections.
Sections 1 through 2.
Members of the committee, you now have before you Senate Bill 184. What is your pleasure, Senator Lenz?
Mr. President, I move that when this committee does rise and report, after having had under consideration Senate Bill 184, recommend the same do pass, Mr. President.
Senator Lenz.
Members of the body of the Committee of the Whole, I bring before you a bill that addresses some structural issues within the judiciary system in CPS cases. You will see it is all on page 2, the top of which, starting on line 1, is that transfer of venue may not be made outside of the county in which the original petition is filed. So cases will remain in the county in which it started. It was argued in committee that a lot of times these cases, if they're moved, if the parent moved, that it would just pick up where it left off. But the reality is that is not happening. If the parent moves to another district, it actually, I use the term reset. It's the only term that I have for that. And to really describe that, and that's effectively what's going on. So it's stringing it out longer. Let's keep that in the district where it's at. We have capabilities through many technologies to address this. And we shorten it. We shorten that time. We keep it concise, to the point. The second point starts on line 12 and is under prohibition of continuances. So other than the exigent circumstances that are listed, continuances in a CPS case would not be allowed. So the state comes ready. They're the ones that probably started this process. They come ready to articulate what's going on. Now remember, starting July 1st, we'll have 5-day hearings for your first hearing. And so the state is coming ready, and oftentimes other people are not. Attorneys are not. Let's have them amp their game too, because we are, once again, why I sound like a broken record, this is a difficult circumstance. Efficiency and getting to the point of the matter helps this circumstance, and I appreciate your consideration. Mr. President.
Are there any amendments?
None, Mr. President.
Is there discussion on the motion? Seeing none, Senator, would you care to close? Senator has closed. Question now arises on the motion of Senator Lensman. This committee does rise and report, having under consideration Senate Bill 84. Recommend the same do pass. As many of those in favor of the motion signify by voting aye. Those opposed vote no. Has every member voted? Does any member wish to change his or her vote? Senator Cuff. The clerk will record the vote.
Mr. President, 34 senators vote aye and 16 senators vote nay.
34 senators haven't voted aye, 13 haven't voted nay. Senate Bill 184 has passed second reading. Members, you now have before you for your consideration Senate Bill 191. The clerk will read the title and history of the bill.
Senate Bill 191, introduced by Fitzpatrick, a bill for an act entitled revising preliminary injunction and temporary restraining order laws, incorporating the federal standard for a preliminary injunction into Montana laws as a general standard for a preliminary injunction or temporary restraining order, requiring the applicant for a preliminary injunction or temporary restraining order to show why an injunction or temporary restraining order should be granted, providing a declaration of legislative intent, amending sections, and providing an immediate effective date.
Are there any corrections to the history and title of the bill as read?
None, Mr. President.
Clerk will read the sections.
Sections 1 through 5.
Members of the committee, you now have before you Senate Bill 191. What is your pleasure, Senator Fitzpatrick?
Well, if you are just joining us, welcome. You're watching a special edition of COS Live, where we are streaming the Montana Senate. Today, we're getting our first floor debate of the year in Montana. We're expecting them to debate and vote on second reading of our Article 5 resolution for a convention of states. You will hear it referred to in this body as SJ2, Senate Joint Resolution 2. So this is the last bill on the agenda today on the calendar before they get to our resolution. So we're expecting to hear in just a few moments our champion, Senator Tom McGilvray, introduce and speak to the resolution SJ2. And then we're expecting a very lively debate. So we're going to go back to the live stream because we don't want you to miss a minute of it. Again, this is the last bill on the calendar today before ours. SJ2 is what we're watching for. Producer G, let's go back to the live stream.
Thinks will actually happen in the case as it proceeds. So I think this is about bringing some fairness into our judicial system, and I'd ask for a green light. Thank you.
Are there any amendments?
None, Mr. President.
Is there discussion on the motion? Senator Morgio.
Thank you, Mr. President and members of the body. I'm going to ask you all to oppose this bill today. When I taking a look at the bill, it appears to me that Senate Bill 191 would transfer powers really to folks who aren't elected judges in Montana. For 100 years, in Montana, we've had our own laws on when to grant or not to grant a preliminary injunction in a court case. For 100 years, Montana judges elected by and accountable to Montanans have decided cases under that standard. What this bill is going to do is it's going to throw all that away and adopt a standard developed by unelected federal standards. We heard today already that we want juries of our peers deciding cases. Well, I think we also want rules that are decided here locally and reflect our values in Montana. And what's even a little more surprising in this bill is that our body wants the Ninth Circuit Court of Appeals to make our preliminary injunction standards in Montana. And what do I mean by that? If you go to page 2, subsection 4, under lines 13 through 15, you can see that it says that the Montana courts should follow the U.S. Supreme Court case law when making decisions. But the U.S. Supreme Court only hears about 70 cases a year, rarely takes cases about preliminary injunctions. I also just think that, when we're going to a higher court, we want to have our standards in place. We don't necessarily have to mirror the same standards of courts above us. We make our own decisions here in Montana, and I think as a result, Montana courts are going to look to the next highest federal authority, most likely the Ninth Circuit Court of Appeals, when we look at the standards again for injunctions. So, I like the standard we have in place. I think we should stick with that. I don't think we should deviate away from that and put things into the Ninth Circuit Court of Appeals or standards that are interpreted by the Ninth Circuit or the Supreme Court. Thank you, Mr. Speaker, or President, excuse me.
Thank you. Senator Gross.
Thank you, Mr. Chair. Question for the sponsor, please.
Will the sponsor yield?
Yes.
Thank you, Mr. President. Senator Fitzpatrick, on page 2 of the bill, so we amended this in committee, and I'm just looking for a clarification here. Page 2 of the bill, lines 4 and 5, they state an injunction order may be granted in either of the following cases between persons, not including a person being sued in that person's official capacity. Does that mean that a preliminary injunction could not be issued or sought against the state?
Mr. President, Senator Gross, no, you will be able to sue the state of Montana.
Okay, I'll speak to the bill, Mr. President.
Senator Gross.
Thank you. Folks, this bill looks a lot like a reaction to the number of unconstitutional laws that was passed by this body last session. But it needs to be said that constitutional cases are exceedingly rare, and the majority of litigants are everyday Montanans with everyday problems. So if this bill is supposed to change the way that courts issue preliminary injunctions, we need to ask ourselves a few questions. How is this bill going to affect a parent whose rights have been terminated? How is the bill going to affect our mining, oil, gas, and timber industries facing regulatory action by the government? Let's just think about, again, the rule of unintended consequences here. How is this bill going to affect everyday Montanans? Let's just think outside of the constitutional cases and think about the unintended consequences. Thank you.
Seeing no Senator Olson.
Thank you, Mr. President. I apologize. I also have a question for the sponsor.
Will the sponsor yield?
Yes.
Senator.
Mr. President, Senator, I'm looking at the lines where we're taking away the ability for an emergency injunction or TRO to be heard before the judge to stop irreparable harm that a delay, even a delay in a couple of days, might cause. So I'm going to give two examples, and I'm wondering if they apply to these situations. One where you might be going to file a conservatorship on your parent, but because you just discovered there was a house closing going to happen tomorrow. And so you knew that this person didn't have the ability to sign all those for sale, and you knew that the person's wife or husband was going to be adversely affected by that sale. Or the second, a child was being taken out of the country that would have been allowed by a parenting plan, but there was a change in circumstances and the plane was taking off in the morning.
Senator Fitzpatrick.
Mr. President, Senator Olson, I think it's a good question, but this bill isn't going to affect that. If you have that emergency situation, you know you can go get the temporary restraining order. You can walk into the court. You can get that 10-day temporary restraining order, get it extended out to 20 days. This law doesn't change that. And then you go before the judge and you get the evaluation on your preliminary injunction. So this bill does not affect the temporary restraining orders.
Follow up.
Follow up.
I'm looking at section, on page 2, section 3, lines 26 was when a restraining order may be granted without notice. It used to be, until we crossed it out, that you could get a restraining order based upon the specific facts shown by an affidavit or by the complaint that you've just filed, that there would be cause of immediate and irreparable harm. It looks to me like we're changing that part that I, as a lawyer, and others have relied upon in an emergency situation.
Senator, do you continue to yield?
I do. Mr. President, Senator Olson, if you want the restraining order, you go in and you file the affidavit and you say, I am likely to succeed on my merits and I am going to suffer irreparable harm. It's the same process. If there's irreparable harm, you'll be able to get the temporary restraining order. You just have to meet the standard of 201.
A follow-up, Mr. President.
Will the sponsor continue to yield? Will the sponsor continue to yield?
Oh, yes, I'm happy to answer all questions.
Thank you, Mr.
Senator.
President. Thank you, Senator. I guess I'm confused then why we're removing this from the restraining order section where it says when a restraining order may be granted without notice. It's referring us back to a section on injunctions that aren't without notice. That's when you get a temporary injunction and it goes forward to a hearing. So I'm confused why we're taking that part out of the law.
Senator Fitzpatrick.
Mr. President, Senator Olson, so I guess if you want the temporary restraining order, you go to the court and you make out the elements of 201. So you would go and say, in your affidavit, I'm likely to succeed on the merits, and you will show why. You will show that you are likely to suffer irreparable harm, and then you will explain why it's in your balance, the equities in your favor, and why the order is in the public interest, and then the court can grant you that temporary restraining order. I don't think this is that difficult.
Thank you. Thank you, Mr. President.
Senator Hertz.
Thank you, Mr. President, members of the body. I've got to rise in support of Senator Fitzpatrick. This is a great bill. Still allows those emergency situations for when you need a temporary restraining order to stop issues. But what it doesn't allow is a temporary restraining order that is not temporary. It goes on and on and on. This is what we're trying to stop, and this is what we need to do. Thank you.
Seeing no further discussion, Senator, would you care to close?
I would, thank you. This is like I said, this is a good bill. I do want to address a couple of questions. There is a benefit actually by using federal law, and that's because federal courts have, over the years, developed a very large body of case law. They can answer all types of questions on when a case is likely to prevail, when you're likely to succeed on the merits. We have all types of provisions in our code that are identical to federal law. We have, for example, our rules of evidence, which are identical to federal law. We have our rules of civil procedure, and they provide nice guidance for people like me who have to look things up. So I think by using the federal standard, we are definitely improving the case law in the state of Montana. I think it will provide a little bit more clarity for people and provide a little less avenues for people to fight over. But I think more importantly, the unintended consequences of all these lawsuits we get, and whether it's the guy who wants to build a house, or he gets sued by his neighbor, or the person who wants to open up a mine, and they get sued and they get hit with these injunctions and they last forever and they never go away, and you have to go up to the Montana Supreme Court, and that's just more time. It's better for the people in Montana to have a standard where you are actually going to win before you get enjoined. I think that's or you're likely going to win. I think that's the fair thing to do. It's the right thing to do. I'd ask for a green light.
Senator Olson, you're lit up. The question now arises on the motion of Senator Fitzpatrick that when this committee does rise and report having under consideration Senate Bill 191, it recommend the same do pass. As many of those in favor of the motion signify by voting aye. Those opposed, no. Has every member voted? Does any member wish to change his or her vote? The clerk will record the vote.
Mr. President, 33 senators vote aye and 17 senators vote nay.
33 senators haven't voted aye, 17 haven't voted no. Senate Bill 191 has passed second reading. Members, you now have before you for your consideration Senate Joint Resolution 2. The clerk will read the title and history of the bill.
Senate Joint Resolution 2, introduced by McGilvery and others, a joint resolution of the Senate and House of Representatives of the State of Montana applying for a convention of the states under Article 5 of the Constitution of the United States.
Are there any corrections to the history and title of the bill as read?
None, Mr. President.
Clerk will read the sections.
Section 1.
Members of the committee, you now have before you Senate Joint Resolution 2. What is your pleasure, Senator McGilvery?
Mr. President, I move that when this committee does rise and report after having under consideration Senate Joint Resolution 2, that it recommend the same do pass.
Mr. Senator McGilvery.
Thank you, Mr. President. What I want to do, first of all, here is just read from the application to the United States, starting on line 26, because I think we ought to read it to see what it says. It says the legislature of the state of Montana hereby applies to Congress under the provisions of Article 5 of the Constitution of the United States for calling of a convention of the states limited to proposing amendments to the Constitution of the United States that impose fiscal restraint on the federal government, limit the power and jurisdiction of the federal government, and limit the term limits of its officials and members of Congress. So, a lot of times when we carry resolutions, you'll hear the thought that, oh, this is just a letter to Santa Claus, this doesn't mean anything, it's just a statement. This resolution is different. This resolution is an application under Article 5 of the United States Constitution, fulfilling a federal function given to us by the framers to apply as an application to Congress for a convention to propose amendments. And it is a limited application. The application says it's limited. You have to impose restraints. You can't increase fiscal power. You have to limit the power and jurisdiction. You can't increase power. And you have to impose term limits. So those are the restrictions of the applications. All applications, and there's been over 400 of them or more throughout history, have either limited their power of the convention or they were unlimited applications. Early applications, some of them were plenary, meaning they were unlimited. Most applications in recent history have been limited, as this one is. It's a legal document. It's limited. I wanted to share with you how I got into this effort to call for a convention of states. In 2007, former Representative Rick Jor brought an application to rescind all previous Montana applications for a convention. I voted yes on that resolution that day. But then one of my constituents, who's out in the gallery today, he's responsible for all these hundreds and thousands of emails you've been getting, so you can blame him. He asked me if I would sit down and chat with him and have tea. So I said, okay, because I do that with all my constituents. My cell phone's on the website. I'm available. If anybody wants to talk to me, I'm ready to talk. So I sat down with him for tea, and he asked me if I was familiar with Convention of States. I said, not really that familiar with it, but I generally opposed. He asked me that day if I would look at the information that he had seriously, and I promised him that I would. When I make a promise, it's an oath. So I was diligent to follow up on that promise, and I went down the rabbit hole after I read what he read because it was intriguing to me. I, at some point, picked up Rob Nadelson's book, The Law of Article 5, and Nadelson is the foremost authority on this, again, a constitutional scholar. cited 26 times by the United States Supreme Court. So he's written the seminal work on this article. And what I began to do is I began not just to read his book, but read the footnotes in the book. And read the literature in the footnotes, the applications to the original convention in 1787, all the applications that went to that convention, all the history of each convention of states, their delegate instructions and what they were to do and what not to do, how each convention of states worked, read the rules of various conventions of states. I looked at every single issue, the worst of it, the best of it, trying to look at every argument and look at the founding and original documents to determine what the issue was. And I came to an epiphany at some point in that study and that work that essentially said, I, as a state legislator, as a member of this body, have an obligation, a duty, and an opportunity to address what's happening in Washington, which I believe every individual in this chamber thinks is dysfunctional. They are out of control. They're fiscally out of control. When I started working on this 2 years ago, the debt was $27 trillion. In just 2 short years, we've added nearly $5 trillion of debt. Members, the issue is here today, that it's not about our children or grandchildren paying the debt. It's about our children and grandchildren having the ability to pay the interest on the debt. That's how serious this is. Not only are they fiscally out of control, they're jurisdictionally out of control. The concept of federalism says that we have certain retained powers, reserved powers. And yet, the federal government, and I would say every Democrat, every Republican in this body, wants to deal with our own affairs here. Our oil, our gas, our coal, our water, our air, our wildlife, our wolf, our grizzly bear. We don't want Washington telling us what to do in these areas, yet they've taken over every aspect of this. I say that Congress has taken on imperial powers and it's got to stop. And also, our federal representatives have simply lost sympathy for us. If you look at what the initial ratification conventions of 1788 said, they imposed term limits. They wanted term limits on both the president, which happened with the 22nd Amendment in 1951, and they wanted term limits on Congress because they believed that Congress would become oppressive and lose sympathy. And they have done that. They've lost sympathy with us. They don't care about us. What they care about is re-election and getting a check from us every time they run. I'll have more to say about that when I close. But I want to just, before we go to questions and answers, I want to read Article 5 because it's important what it says and what it doesn't say. Article 5 says that Congress, whenever 2/3 of both houses deem it necessary, shall propose amendments to this Constitution, or on the application of 2/3 of the state legislatures shall propose amendments to this Constitution, which in either case are valid parts of this Constitution when ratified by 3/4 of the states or in conventions of 3/4 of the states, whichever mode Congress shall choose. This says that there's 2 ways to propose. Congress can propose, and they proposed all 27 amendments. And it says the states can propose. The original idea of Article 5 happened at the Constitutional Convention of 1787, where George Mason stood up and said, listen, guys, he may not use those words, but he said something like that. He said that there will be a point in the history, in the future, where Congress will become oppressive. And the current text of Article 5 at that time had Congress in charge of both modes of proposing amendments. We could apply, but Congress would propose the amendments. So the point here that Mason said is that we have to have a dual process. We have to have a process where Congress can propose. We also have to have a process where the states can propose and do that in convention. So the idea of a convention to propose amendments is a congressional bypass. That's why Congress can't control this convention, among other reasons. It is designed as a congressional bypass. It also says on the application. On the application means that it is an application. The word application is similar to what our common application term means. You know, a good senator in the front aisle, Senator Brown, if you make an application to the state of Montana for a moose permit, and with that application that you've made, if they grant you that permit, you don't get to go out and shoot an elk. If the warden comes and you've got an elk at your feet with a moose application, you're in serious trouble. It is no different here. This is a limit application. If you go off application, you're ultra vires, you're out of order, you're beyond the law. It's based on the application that you have in front of you. You cannot go off that, you can't go beyond it. And of course, it's ratified by 3/4 of the states. There's been suggestions that the convention to propose could change the ratification method. That's insane. We've had multiple Supreme Court cases, Dry versus Blair, U.S. versus Sprague, and on, that have said, you can't change the ratification method. It's 3/4. The law of Article 5 says you can't change the ratification method. That means you got to get 3/4 of the states, legislatures or conventions in 3/4 of the states. Think about it. We are 2 chambers here. That means we have 99 legislative chambers in America. If you're going to go through the state legislators to get an amendment passed, you need 87 of the 99 chambers. That is a high bar. In the ratification era, when they were ratifying this document, the complaint was, this is too hard. We've all of a sudden taken the myth that this is too easy. Let me tell you, it's not easy. It is hard to get an amendment to the U.S. Constitution through a convention to propose amendments. It's a high bar. Members, I'm going to sit down here. Before I do, let me make one more point. This application gives us, state legislators, authority to push back on what Congress is doing, which everyone in this room, I believe, would think is dysfunctional. When you're given authority and power, it is your obligation and your duty to exercise it. The citizens of Uvalde, just a few months ago, there was a police force that had the power and the authority to go in and stop that shooter, and they were derelict in their duty and they did nothing. Back up a year and you had Parkland. You had the resource officer with the power and the authority to go in, and he did nothing. And both of those groups did nothing because they were afraid. Fear is not an option for us. I'll sit down and take questions. Thank you, Mr. President.
Are there any amendments?
None, Mr. President.
Discussion on the motion, Senator Gillespie.
Mr. President, mine won't be near as long and dramatic, but I just feel, you know, gosh sakes, we go home, we watch the news, and we just wonder and say to each other, how much longer can this insanity last until we all become like Venezuela or gosh knows. I served some time in Peace Corps, and it wasn't like Venezuela is now, but it's not an easy hole to dig yourself out of when you get that far underground. And it seems to me like we've been sliding downhill so long, so hard, and so fast that we just don't know anything different. And unless something like this can slap us back into reality, it's just going to keep doing that. Congress, the minute they quit giving us free money, which we think is free money but isn't, it digs that hole deeper, we're not going to vote them in. That's what should happen, but they know how to get voted back in, is to keep giving us goodies. And so I think something like this, I don't think the risks are near as high as some think they are. It looks like it's pretty well contained to me, and I guess I'd a lot rather be on the side of not just sitting there criticizing, but at least trying to do something that might, like I say, slap us all back into reality. Thank you, Mr. President.
Senator Zolnikoff.
Thank you, Mr. President. I have a question for the sponsor.
Will the sponsor yield?
I'll yield.
Thank you, Mr. President. Senator, so I've seen quite a few emails that suggest that Congress will control the convention and the appointments of commissioners and a lot of those issues. Can you address that?
Thank you, Senator. Yes, I can address that. Again, I said a little bit about that when I was opening here. The whole meaning in every provision of the Constitution should be given some meaning. The meaning of Article 5, the convention to propose, is a congressional bypass. The framers would not have permitted the idea that you can use Article 1 powers to control Article 5 powers. All federal functions of Article 5 flow from Article 5. And I even want to read a case, Idaho versus Freeman, on that question, and it'll be very brief. But it says, to begin with, the actions of Congress in relation to a proposed amendment must be properly characterized in order to approach the questions presented. First, it must be recognized that Congress's power to participate in the amendment process stems solely from Article 5, as Justice Stevens noted. The function of a state legislature in ratifying a proposed amendment to the federal Constitution, like the function of Congress in proposing the amendment, is a federal function derived from the federal Constitution, Dry v. Blair. Thus, Congress, outside of the authority granted by Article 5, has no power to act with regard to an amendment. In other words, it does not retain any of its traditional authority vested by Article 1. So multiple cases have said your Article 1 statutory powers of Congress, their lawmaking powers, do not apply to Article 5. All amendment power flows from Article 5 as in controlled by Article 5. So no, Congress cannot control this convention. And even as Senator Ervin, who was in the 60s and 70s, tried to draft some legislation to do that, never made it. It failed along the way, Mr. President.
Thank you, Mr. President, members of this chamber. So I just wanted to read a little debt timeline. In 1981, we hit 1 trillion. 1986, 2 trillion. 1990, 3 trillion. 1992, 4 trillion. 96, 5 trillion. 01, 6 trillion. 04, 7 trillion. At that point, I was in graduating high school in 05, where I did my term paper on the national debt. A little over 7 trillion. That was scary. That was scary enough to get a 18-year-old high schooler interested in the government. 06, 8 trillion. 07, 9 trillion. 08, 10. 09, 11. 10. In 2010, 13. 2011, 14. 2012, 16. 2014, 17. 2015, 18. 2016, 19. 2017, 20. 2018, 21 trillion. 2019, 22 trillion. 2020, 27 trillion. 21, 29 trillion. 2022, 30.8 trillion. Today, about 31.459 trillion. I read a few different articles on the interest today. One said 320 billion, another was a little bit different of projections, but that's about 5%. Interest is expected by 2031 to be over 900 billion a year, more than we spend on defense. In 8 years, we're going to be spending more projected on interest. That is at current projected interest rates. But if we look at the average interest rate paid on the national debt in 2021, it was 1.5. If we look at what we paid in 2001, the interest paid on the national debt was 5.4%. If that interest rate was hitting that, if our interest rate was at 5.4%, our interest payment would be $1.4 trillion today. I also opposed this in the past, worried about our Second Amendment rights. I think we have a bigger problem to worry about today. I know that there are other concerns, but we're going to be paying more on interest in a decade than we are going to do on our national defense. We are going to lose the value of our dollar. We're going to lose capital overseas. We are going to be in a very rough spot. We think people can't pay for things now. Just wait as our dollar plummets. So, I'm kind of there. Why not take the risk? It's not our kids or grandkids. It's the people in this room who are going to be feeling this, and we already are.
Senator Manzella.
Thank you, Mr. Chairman, members of the Senate. Here I go again. The opposition to the Article 5 Convention. Reasonable people, equally informed, seldom disagree. Making sure that everyone is equally informed is a challenge. That is the hard part. And this is an issue that we really need to be equally informed on because our Constitution, our beloved Constitution of this great country, is at stake. We've asked repeatedly for an open public debate, and to this point we have been denied. The reasonable mind might ask why. So, without a public debate, we have no choice but to look at history and look at some of our source documents. One is Black's Law Dictionary, which is considered the premier authority on everything legal. You might Google, you might ask it to search for a convention of states. Nothing shows up. Why? If this is such a often used process, does Convention of States not show up in Black's Law Dictionary? Neither does Convention of Deputies, which is a new one. What does show up is a constitutional convention. And the definition of a constitutional convention is a duly constituted assembly of delegates or representatives of the people of a state or nation for the purpose of framing, revising, and amending its constitution. Does that not sound like what we're talking about here? We are talking about a constitutional convention for creating amendments to amend our Constitution. If you haven't read the Federal Convention Act of 1973, I encourage you to do so. Section 7, delegates. A convention called under this act shall be comprised of as many delegates from each state as it is entitled to senators and representatives in Congress. That doesn't sound like one state, one vote to me. If you haven't read the Article 5 Convention to Propose Constitutional Amendments, dated April 11th, 2014, I suggest you do so. If you haven't read the National Archives Constitutional Amendment process, I encourage you to read that. Lots of great information to be found on this issue in those historic documents. I'll share a little bit with you about my experience with the Article 5 Convention. You know, it's sad because we agree on so much. We agree on so much. The federal government is out of control, no doubt about it. The judicial branch is also equally out of control. The proponents of this bill have been referencing the Constitution annotated regularly as of late. That's kind of a new one to me. I'm not familiar with the Constitution annotated. I take an oath to uphold the Constitution, not the Constitution annotated. The Constitution annotated, if you don't know, it's all about how the Constitution has been amended through case law. So a lot of the problems that we are facing is that the judicial branch has legislated from the bench, as we're all well aware, and created many of the problems that we face today through the Constitution annotated. One of the things I guess I don't necessarily agree with is that it's all the federal government's fault. It's not. We, as state legislators, have been given the duty to give the Constitution effect. And when we consistently are taking the money on all the issues that we face in this body, we're taking the strings that are attached to that money. So often, that's what we're doing. It is our responsibility to limit the federal government, but we already have the power to do so through our Constitution. So I got involved in politics in 2012, and as a vehement supporter of states' rights and a very strong-willed individual, I read the Liberty Amendments by Levin twice. It was a great book. I got excited about the possibilities of the amendments. I readily admit that, until I listened to the opposing arguments. And there's lots of multiple opponents on this issue. It's not just one group that's opposing. There are hundreds of them that oppose, and there's lots of historical documentation on it. So I've been studying the issue for over 10 years now, and to date, despite having an open mind, hoping that there is something that we actually can do along these lines to rein in the federal government, I haven't found it. I don't argue that it's Article 5 is constitutional. The framers made it clear that it is. My question is it wise and prudent to attempt to amend our beloved Constitution in the environment we found ourselves in? How many Alexander Hamiltons and Madisons do we have, do you think, in our entire country? With the exception of the good Senator Molnar. You have two handouts on your desk I'd like to ask you to look at. It is my belief that an Article 5 in this environment is extremely dangerous, and of course I'm not the only one. There's lots of precedents to support this. And I encourage you to keep this document and review it at your leisure. It's all footnoted. It is citing historical quotes from the founders. Again, what we are talking about is a constitutional convention, much like the one that we had in 1787 that gave us our great convention. And if you look at page 1 there, you can see under column 1, some said, "We don't have the power and we should not proceed." Patrick Henry. They exceeded their power is perfectly clear. That they exceeded their power is perfectly clear. That was Patrick Henry. Others said, "We don't have the power, but we should proceed anyway." Edmund Randolph indicated that there are great seasons when persons with limited powers are justified in exceeding them, and a person would be contemptible not to risk it. And I believe that that is similar to what I hear the good senator who's proposing this say, that there's risks, but we need to take the chance. None of them said, not one of them said, that they stayed within the parameters that they were given by their state delegations. And if you can find a citation that indicates that they did, there's $10,000 for you. That's a lot of money. Somebody should take us up on that. To date, no one has. In 2015, I was a freshman, wet behind the ears. I had decided by that time, though, that I couldn't support a convention of states because the risks did not outweigh the benefits. But to their credit, they invited me to be a delegate to the historical event, the first ever simulated convention of states. And they invited me knowing that I was an opponent to the whole idea, but they thought they could change my mind. God bless them for that. I mean, I appreciate that kind of openness, right? So off I went to historical colonial Williamsburg on September 21st through the 23rd, 2016, to be a member of this historic event. You're welcome to look at this book, anything in it. It's the agenda, the rules, the committees are all laid out in it. On your desk, you have another handout, and this is what we came up with. You can find this today. I took this actually off of their website. Statement of convention. The convention respectfully submits these proposals to the American people with the conviction that they are a sound beginning to a critically needed national discussion about restoring the balance of power between the federal government and the states. Further, it is the conviction of this body that the states must deliberate and adopt appropriate proposals for balanced budget amendment and an amendment to provide the states a means to serve as a check on judicial overreach by the federal judiciary of the United States. And if you turn the page, this was the committee that I served on, which was the Federal Legislative and Executive Jurisdiction Proposal Number 2. Now, this committee was largely attended by well over 90% Republicans. Many of us claim to be constitutionalists, loving our country. And this was the amendment that we came up with. Section 1, the legislatures of the state shall have the authority to abrogate, and abrogate means to repeal, do away with, or evade. To abrogate any provision of federal law issued by the Congress, President, or administrative agencies of the United States, whether in the form of a statute, decree, order, regulation, rule, opinion, decision, or other form. And again, I was there. I can't help but get excited about the idea of making the Constitution better, right? And then you realize when you attempt to reconcile that proposal with Article 1, Section 1 of our current United States Constitution, all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. You realize that that proposal that we came up with, that was the best that we could do at this historical simulation, that cannot coexist with Article 1, Section 1 of our current Constitution, because it's very clear that the president doesn't make law, the administrative agencies don't make law, statutes are law, but decrees, orders, regulations, rule, opinion, and decisions are not law. So where is that going to fit? How are we going to fit that into our Constitution without removing Article 1, Section 1? You can't do it. You simply can't do it. And again, that was the best that we could do. So it was a humbling experience for yours truly. I won't be going to any convention thinking I'm going to make the Constitution better. I can assure you of that. Don't pick me. I don't want to go. I don't want to be responsible for destroying the Constitution. And I close with the wise words from George Washington. If in the opinion of the people, the distribution or modification of the constitutional powers be in any particular wrong, let it be corrected by an amendment in the way which the Constitution designates, but let there be no change by usurpation, for through this, in one instance, may be the instrument of good, it is the customary weapon by which free governments are destroyed. And what we came up with at the Convention of States was purely and completely usurpation. Please vote no.
Senator Friedel.
Thank you, Mr. President. I wanted to talk to the body and the people in this floor that the good senator from Billings, Senator McGilvery, I respect him. In fact, I think he's a good friend. We've had a lot of conversations about this. In fact, there are some aspects that I can even call him a mentor. I'm ecstatic that people are talking about the Constitution. We're having conversations, and hopefully everybody in this room has read them, all 27 amendments. After rereading it again, I have no doubt that we have the ability through the Article 5 to initiate a convention of states and have this conversation. But one of the things I would argue is our handful of amendments that we do currently have in the books, that I believe that even though we've gotten to that census, I think we failed. If you've read our Constitution, you know that there's one about prohibition of alcohol. How many of you think that should be a constitutional amendment? Luckily, we came back and had another amendment to repeal that. How many of you believe that the 16th and 17th Amendment is a good idea? One allowing the federal government to reach into our pocketbooks, and the other one allowing for us to vote on senators, knowing that that's the state's house, and the representatives are the people's house. Do we think it's a good idea with the political polarity that we have right now in our country, that we as, whether you're Republican, Democrat, or other, think it's a good idea that we're at each other's throats about what we should do, and yet not unified in saying, what is the problem we have with Congress? I think the biggest thing is the question I have is not whether we can or cannot do a convention of states, is whether we should or should not. I ask this body that when you sit down and you proceed to push the button, to think about it before you make your choice. Thank you for your time.
Senator Morshow.
Thank you, Mr. President. You know, for me, I'm not going to be able to support this bill. I don't think it's a freedom bill. If you know me, you know I like my guns. I don't want anybody fiddling with that right. So I ask you to vote no for freedom. Thank you.
Senator Hertz.
Thank you, Mr. President. I've got 31 trillion reasons to support this, and 4 wonderful grandchildren. We're sitting here just waiting for our federal government to do something that they should do. I've been waiting for many years. When was the last time Congress even passed the budget? The presidents on both sides have overstepped their bounds. The judiciary has. We don't wait around our state houses to take things on and do what's right. I'm sorry, I'm willing to take the risk. This is the only way we're going to rein in our federal government. There's no other way that I can see us to do it. And as a fine representative from Billings pointed out, our debt and the interest on that is out of control. You look at the interest rates that have been artificially held low for many years, that have trickled through the economy and created many other problems, and now the Fed can't even control holding those rates artificially low down. These interest rates are going to eat us alive here in our budget. The interest alone could be 1,500 to 2,000 years of Montana's budget. Yeah, we get some money that comes into the state. It's about equal to 2 or 3 days of interest on the national debt. That is so large, it's hard to imagine how big $1 trillion is. Most calculators won't even allow you to put $1 trillion on it and do some easy division. It's impossible. Unless you start getting rid of some zeros, which even as an accountant, I get a little confused and I got to start crossing out zeros and figuring out what's $1 trillion if I divide this into it, what's $1 billion. So we need to do what's right for our children and our grandchildren. Vote yes, please.
Senator Emmerich.
Thank you, members of the body. I would like to talk about the intent of the founders. They put this in the Constitution with instructions. In fact, they put 2 provisions in the Constitution with instructions. And the instructions were that when a government becomes destructive to its own ends, that it was the duty of the citizens to overthrow that government. And at this point in our country, all we see is the government doing things that are destructive to its own ends. And the framers were very wise, in my opinion. They gave us two ways to deal with this. One was a civil way, and one was a very uncivil way. One was with a constitutional convention, and one was with pulling a trigger. And I, for one, do not want to go down that second path. And I think that the founders had it right when they said that they gave their lives, their fortune, and their sacred honor. Stand before you today, I can't ask for your lives. We know all too well that the cause of liberty is washed in the blood of patriots. It's already been taken from us. I can't ask for your fortune because that's already been taken from you as well. The only thing that we have left is our sacred honor. And the one thing we have left that we can do with that sacred honor is, unfortunately, push a green button or pull a trigger. And I, for one, would want to push a green button for the cause of liberty. Thank you.
Senator Lenz.
Thank you, Mr. President. Question for the sponsor.
Sponsor, yield.
I'll yield.
Senator McGillivray, would you address, we had this put on our desks, mentions a $10,000 challenge, and to find a citation of the 1787 convention that the delegates acted well within their state delegated power. Would you address that, Senator?
Thank you, Mr. President. Senator, yeah, I'd happily address this. I have 4 citations here. Anybody can have them to pick up the 10 grand. I'll read them to you. I don't know if the person that made this challenge has $10,000, but free for the taking here. This has been researched, and had that person done his own research, he would have known this. Madison of Virginia in Federalist 40 argued that commissions issued by the states were the source of the delegates' powers. Powers of the delegates were this: the Virginia ratification, the Virginia application to the convention in 1787 said this: devising and discussing all such alterations and further provisions as may be necessary to render the federal constitution adequate to the exigencies of the union. 7 states, actually 10 states, had that same commission. So they went there with the ability to alter anything they needed to do to create a government that would function, and they successfully did that. After the convention, there were arguments. The Anti-Federalists said, these guys didn't have the power to do this. The Federalists said, yeah, we did. But here are the citations that address this specific thing. James Wilson of Pennsylvania stated on the convention floor, with regard to the power of the convention, he conceived himself authorized to conclude nothing but at liberty to propose anything. Charles Cotesworth Pinckney of South Carolina, another delegate, said, it had been alleged that when they exceeded their powers, he thought not. They had a right, he apprehended, to propose anything they imagined would strengthen the Union and be for the advantage of the country. William Davie of North Carolina, another delegate, addressed the lack of authority, saying, quote, this objection has been industriously circulated, but I believe on a candid examination, the prejudice on which the error is founded will be done away. And he goes on to say, he says, what was the subject of our mission? To decide the most effectual means of removing the defects of the Union, this in a general discretion authority to propose any alteration they thought proper and necessary. 4 citations. Pick up your 10 grand.
Thank you, Mr. President. I would like to speak to the bill.
Senator Lenz.
Senator McGillicuddy, it looks like you're the winner. Thank you for offering that to everybody else. That looks like you're the winner. I guess I'm struck by mentioning the respect for the Constitution, but then acting like it's so fragile. Like we have created, the states created this, and then they set it in the china cupboard, and boy, we never touch that. Not even when grandma comes to visit, because it's just so fragile. Our Constitution is not that fragile. It was created for us. It was created for us to use. God bless we live in a nation where we have that Constitution. I'm struck by how afraid we are. And we're afraid of the wrong things. Our government is out of control. We should be afraid of that, not afraid of stepping up and taking the reins that were established in the Constitution to make a difference. And I would encourage you to take courage and vote yes.
Senator Beard.
Thank you, Mr. President, members of the committee. I'm just here today to remind all of us here on the floor and up in the gallery that your elected officials take an oath to abide by the words in our U.S. Constitution and our state's Constitution. And in the U.S. Constitution, we have seen the flaws at the national grandiose level when our elected officials out in Washington, D.C. flagrantly abuse our Constitution and their oath of office and their service to us, to all of us. Whose fault is that? We voted them into office. Each and every one of us here has cast votes for our sons of guns, but at least there are sons of guns. And you know that this has happened over and over again through my brief time on this planet. They are out of control. Our debt service on the exploding debt that we have, the $31 trillion, well, hey, we keep taking the federal dollars in the state of Montana. We keep taking that because if we don't take our portion, somebody else will. Well, when we take that portion of federal funds, we are taking the red tape and strings attached to that money, which also drives up our costs at the state level. Our responsibility is our vote. I am so heartened, and I've shared this with the constituents, and I see a few of you up there, thank you. I've shared this, that I am so heartened that more people are picking up the Constitution and at least familiarizing themselves with articles within it. And I'm very heartened that we're putting some emphasis back on teaching civics and history in our public schools. We need to do that because we are losing this fight. And adding more words to our Constitution, who's going to abide by it? We have the Constitution now and they're not reading it, they're not abiding by it. And who's holding them accountable? Who's policing that? It's just like gun laws. We keep adding gun laws, but nobody's enforcing the ones we already have. So it's our responsibility, and until I see that our officials in Washington, D.C. are abiding by their oaths of office, I am not ready to press green on this Convention of States. Thank you, Mr. President.
Senator Molnar.
Thank you, Mr. President. 2 years ago when this was up, I didn't speak. And this time, because I have friends on both sides, if either one called me at 20 below one winter's night and said, my water's froze up, can you come help me? I'd put on my long johns and go. So I'm not going to comment on what they said. I'm just going to share with you what I know and how I decide questions like this that are before us. I know that when President Obama was president, in 8 years, he raised the debt $7 trillion. I know that when President Trump was president, he raised the debt $7 trillion in 4 years. This is not a partisan question. I know that when this started 2 years ago, we were at 28 million. 2 presidents raised the debt 50%. I know that in the last 3 years, we've gone to 31 trillion, with the Fed raising interest rates to dry up money, and the President and the Congress, both parties, raising the spending. You can't dry up money while you're pumping money in. It just depends on which pump is bigger. So I'm going to share 3 things with you. That was one of them. The second one is, it might sound at first like it's off point. It's on point. How does the world look at us when we're doing what we're doing? I'm not a volunteer, but I do listen to a lot of Chinese radio, and I ask my wife what they're saying. Recently, I said, that guy's really excited. What's he upset about? She said, no, this is the Chinese public radio, not the guys from over here. And he asked the question that if democracy and free enterprise are such good ideas, why does the American government have to borrow money from us for their daily needs, even building a bridge? If you have the answer to that, vote your conscience on this. America is the beacon of hope around the world. But we have to borrow money from the Chinese for our defense budget? How bright and long is that light? If you're making decisions based on fear and because you're out of options, you've waited too long. In 1993, when I was a freshman legislator, I moved Article 5 in state administration. On one side was Don Judge, head of the FL-CIO. Sitting next to him was the head of the, I knew her name a minute ago, it'll come to me, Phyllis Schlafly. I said, you want me to try and get this out of committee? He said, what base? Left and right or opposed? And since 1993, the rate of inflation is such that $1 in 1993 today has the purchase power of a penny. A penny's worth of candy. For a good candy bar, it's $3 or $4. A few years ago, you could buy a whole dang bag of them. That's what we pay in inflation, never mind covering the debt. How much of our budget today, our surplus, is just inflation of no real value, doesn't buy anything. So that's the question before us. We have a problem. We all acknowledge that. Near as I can tell, we have 2 solutions. We take action, or we live in fear that something may happen. One says, I think this will happen. The other says, I think that will happen. I say the lack of action will cause nothing good to happen.
Senator Brown.
Thank you, Mr. President. Just in the matter of time here, I'm going to be somewhat brief. As you all well know, I'm a pretty straightforward guy, and I kind of run unscripted. I don't plan what I'm going to say, and I don't write it down. I got a few notes here jotted down, but to give you a pre-planned speech, I'm not going to do that. But I can tell you that there is risk. I've been told by the sponsor of the bill that there is risk. I've been told by some of my friends who are the biggest proponents of this that there is risk. We can't, we may be able to limit ourselves as a state of what amendments we're going to propose, but I don't believe that we would put up with any other state telling us exactly what amendments we're going to propose any more than they will put up with what we do. Congress is going to call a convention. We know how Congress works. They are going to play the political game. They will use it, and they will call it in the manner, whether it be by the voice of the legislatures or by conventions of the states. And as I was just reading here, it was kind of interesting. I'm not an attorney by any stretch of the imagination. It says, or by conventions in 3/4 of the states thereof. Does that tell me that they only need to have a convention in 3/4 of the states? Is that something we could argue? Possibly. So means of ratification. I believe Congress will, they will call a convention if we ask for it. We don't know when they will call the convention. I believe they'll call that convention after they have done their political game and impose their political will on others to get the outcome that they want. We know how it works. We know how it works here on a limited basis in the state. Some of us can trade votes sometimes for one thing and to get a vote on another. We will do that. That will happen in the convention. The division here that you see in this body, I have great friends on both sides of the issues, and I don't want of this issue, and I don't want that to jeopardize that. We see those divisions, and we see how deals are made here. We know how our rules are made, right? It's obvious. The majority gets together and decides what the rules are going to be. It's going to be the same thing in a convention. Those games, and I know we don't like to call those things out on ourselves, but that's what it is. It's a political game that gets played, and it gets played often here on a state level, and even more so on a federal level. With that said, I will be a no. I will always be a no. I have told one friend that the only way I will ever vote for this is by the same way I got into politics. It's because I believe God told me it was the thing I was supposed to do. That is why I'm standing here today. And when God tells me to vote for this, and I really believe that, I will be the first yes vote. But until then, I'm a no. Thank you.
Senator Asp.
Thank you, Mr. President. Would Senator McGilvray yield to a question?
Will the senator yield?
Mr. President, I yield.
Senator McGilvray, you heard today, and we've heard in the hallways, that the convention won't stick to the issues in the application. Can you address this before I speak on your bill?
Yeah, thank you, Senator. First of all, again, this application is a legal document. It's an application to Congress. We pass legal documents all day long here. We pass a legal document. If it goes to court, the court's going to look at what the proponent said. The court's going to look at what the sponsor said. The court's going to look at what the bill says. In this case, they're going to say, well, the application says it's limited. 34 sponsors in 34 states said it's limited. And by the way, this application of these 3 prongs are identical to what 19 other states have passed. So they're going to look at what the sponsors have said, what the proponents have said. It's limited. And lastly, they're going to look at history. Anything in the Constitution is going to look at history to see how do these conventions of the states function. The conventions of the states functioned all the same. They all had similar rules. Each state was sovereign. Each state selected their own delegates. And yes, if you look at the applications, they call them conventions of the states. They call them conventions of delegates of the states. I can find you the literature and the applications that say those things. So that's how it works, just like how it works in this body. It's a legal document. If it goes to court, it's going to be clear that it's limited. Thank you.
Thank you, Mr. President. May I speak to the bill?
You may.
Mr. President, members of the committee, I usually don't get up and say much on anything, and I'm usually pretty brief when I do. But I just want to touch on a couple points. The document that's on your desk doesn't show us exactly what the call of this convention was, but it shows she had 3 proposals that came out of this general statement, I guess. I don't know where they came from. But I would ask all of you to read those 3 proposals, which was the best that they could do by the admission of the good senator seated next to me. And ask yourself, do you think 3/4 of the states in our United States would have ratified any one of those proposals? I don't think so. Because the light of day is going to shine on them between the time they were adopted and the time that each state got to vote. They're not going to be able to have an understanding that was just those 3-4 days the convention met, or weeks, whatever it was. They're going to have months and months to listen to arguments both pro and con. And I submit to you that I don't think any of those 3 proposals would have been adopted by 3/4 of the states in this country. You know, the call in the resolution that the good senator from Billings brought to us says amendments that impose fiscal restraints, i.e. balanced budget amendments, something like that, limit the power and jurisdiction of federal government, and limit terms of office, term limits. Those are the only 3 issues that they can address, in my view, in the convention. So, you know, about a year ago, 9 months ago, I got to witness a forum in which a very articulate person made some of the arguments that my seatmate, Senator Manzella, made, and I got to witness the good senator from Billings give a presentation of about equal length. And if I had any doubt before that, I had no doubt after that, that Senator McGilvray is on the right track. This is what we have to do to make our government work for us. I urge you to support the resolution.
Senator Nolan.
Thank you, Mr. President. I think the words have already been said on everything that I was going to address, except I wanted to say, let's send a message that Montana wants our federal government to change course. And this way is one way to get their attention. It's been said, if we do nothing, what happens? What changes? Is our budget going to go down? If we do nothing, we have the right here and the opportunity to be the 20th state to say Montana stands for these specifics. And I just wanted to make sure we all understood what those particulars are. It's imposing physical restraints on the federal government, limiting the power and jurisdiction of the federal government, and imposing term limits on Congress and federal officials. Let's be bold. Let's not be fearful. You know, the scriptures tell us not to be afraid. Let's be bold and let's not be fearful. Let's stand for truth. Let's fight for the cause of our country and vote green.
Senator Pope.
Thank you, Mr. Chair, members. I sit on the committee that heard this bill, and I wanted to share with the body why I'll be a no vote on SJ2. Mr. Chair, members, this is an important conversation, and I respect both sides of this conversation because I think in our heart of hearts we all believe that there are things that need to be changed at the federal level. We also believe and love the Constitution that has taken us this far in this country to be a world leader on so many levels. Mr. Chair, our Constitution uniquely provides for the fair and equitable process for addressing our many complex national economic and social issues and other issues while representing the will of the American people. But this bill proposes, SJ2 proposes, our authorizing Montana to apply for a process whose legitimacy in Article 5, despite what we're hearing today in the back and forth, remains hotly debated, leading to, at the very least, expensive and lengthy lawsuits, likely all the way to the U.S. Supreme Court. Mr. Chair, members, this discussion is not about our grievances regarding the federal government in 2023. And I'll remind the body as we build a budget for the next biennium in this body that, like it or not, the federal government is a very good partner in our efforts to deliver essential services to our constituents while balancing our state budget. Instead, this discussion is about process. Our committee heard that a convention of states would put in motion a process that, as of today, has no written nor agreed upon rules and no assurances of due process. It's a clean sheet of paper. No agreed upon definition on the number and qualifications, Mr. Chair, of representatives to the convention. Who are they? And under what rules are proposed amendments to be debated? Or what will be the voting procedures and the challenges to those procedures and protections to public participation and transparency and the many other important sideboards like those that we enjoy right here in this body every day that protect fairness and proper order and public trust in the process. And I ask the body, are we willing to submit our most treasured organizing document, the U.S. Constitution, the law of the land, to an unknown and unpredictable process that could irreparably overturn central elements of that document, which is a remarkable expression of our freedoms to the world and that guarantees our collective and individual rights and our identity as a nation. Mr. Chair, respectfully, members, respectfully, I emphatically suggest that Montana should not go down this path. Please vote no on SJ2.
Senator McGilvery, seeing no further discussion, would you care to close?
Yeah, thank you, Mr. President and members of the body for a lively discussion today. I just want to address a few of the things that were brought up. We have rules. I hold in my hand right here the 2017 Phoenix Planning Convention, which was a convention of the states that met in Phoenix in 2017 and developed rules for a balanced budget convention. These rules were modeled after the rules of many other conventions of the states. What opponents never bring up is that there were nearly 40 conventions of the states, all with similar rules, all with similar functions, all honoring their instructions, all honoring their oaths. We never bring that up, but that's the facts. What about the facts that there have been over 40 different cases up to the Supreme Court, federal courts, that have addressed nearly every issue around Article 5? These cases are never brought up by the opponents because these cases say things they don't want to hear, even cases that I read today. Let me close by saying this without drawing this up. There are several federal functions in the United States Constitution. Article 4, Section 4, Clause 4, the times, places, and manners of choosing senators and representatives shall be prescribed by the state legislatures thereof. It's our job, it's our federal function to manage federal elections from the state. Yet H.R. 1 earlier this last year sought to take that away from us. Another federal function that the $1.7 trillion spending plan that just was passed in December went after was our Article 2 function of appointing delegates to the or electoral college electors. That bill undermined and took away our function as state legislatures to appoint electoral college electors. Is that what we want to put up with? Article 4, Section 4 gives us the ability to apply to the Congress, to the Washington, if we have an invasion or if our cities are burning or if there's domestic violence. Would we take those three federal functions and say, nah, we don't really want to manage our federal elections. Nah, we don't really care if we get to choose our electors to electoral college. And if our cities are burning like some cities burnt last year, are we going to say, nah, let's not act on that federal function to call in help? And then we come to Article 5, another federal function, given by the framers when Washington is not responsive anymore, when they have become abusive, oppressive, and are doing things that are detrimental to the foundational nature of our nation. Madison said this in a quote, and I quote him in a letter he wrote to Edward Everett in 1830. He said this, and this was one of his last letters before he passed away. He said, should the provisions of the Constitution as herein reviewed prove not to secure the government and rights of the states against abuses and usurpations by the national authority, the final resort within the purview of the Constitution is an amendment to the Constitution according to the process applicable to the states. These framers and ratifiers believed that Article 5 Convention to Propose was a process to check federal power when it's becoming abusive. It's been mentioned that we take an oath under Article 6 to support this Constitution. I'm asking you today to support Article 5, a convention to propose amendments. I brought SJ2 because the fiscal issues are serious. Good Senator Zolnikoff brought up the fact of the trillions of debt that we've been accumulating and the interest payments. The preamble of the Constitution says that we should provide for the common defense. You cannot provide for the common defense when you're spending more on interest payments than the entire federal budget for defense. You can't do it. You cannot provide for the general welfare or secure the blessings of liberty to ourselves and our posterity if you don't have the option to propose an amendment when Congress won't. Do you really think Congress would ever propose an amendment for term limits? Do you really think they'll ever propose an amendment for fiscal restraint? The reason they won't is because it's about control. Congress is imperial. They want to control you, your family, your money, your health care, everything in your life they want to control. Remember that our forefathers did not fight a war against the British. They fought a war against big, centralized government that tried to manage every minutia of their lives. And here we are, full circle, 240 some years later, or 250 years later, with the same problem. What they fought for, we need to fight for. Every provision of the Constitution should be given some meaning. And this provision has meaning for such a time as this. Many times when I speak on this issue, I tell a story. About my grandchildren. So one day I'm working on Article 5 issues and I have three screens in my office. On my right-hand screen, I had the debt clock up. And I don't know if you've all seen the debt clock. If you have never seen it, just search it, us.clock.com. On the right screen was a debt clock running red numbers, trillions and trillions and trillions of debt. 277 trillion of unfunded liabilities. $12 trillion of guaranteed debt for Fannie Mae, Freddie Mac, etc. And my little grandson, Harrison, who was 6, came in and sat on my knee. He said, "Papa, what's that?" I said, "That's the debt clock." Harrison, my other grandson, 7, comes in at the same time and says, "What's the debt clock?" I said, "Well, that's Congress spending more money than they have." And then Henry said, stop? Why won't it stop? That young man didn't understand what he was saying. But it hit me. Why won't it stop? I suggest that it won't stop because state legislatures in this nation will not take up Article 5, do our duty, and send an application to Congress to force Congress to stop. They won't stop on their own. As Reagan said, Congress will not discipline itself. We have to rely on the states to force them to act on our amendment. That was a balanced budget amendment. You can't secure liberty. You can't provide for the common defense. You can't ensure domestic tranquility if every edict and all these rules and laws are coming down from Washington, dividing us as states. We have to unite. Members, I ask you for a green light today. This resolution is about the economic survival of our nation. I ask for a green light. Thank you.
Question now arises on the motion of Senator McGilvery that when this committee does rise and report having under consideration Senate Joint Resolution 2, recommend the same do pass. As many of those in favor of the motion signify by voting aye. Those opposed vote no. Has every member voted? Does any member wish to change his or her vote? The clerk will record the votes.
Mr. President, 26 senators vote aye and 24 senators vote nay.
26 senators having voted aye and 4 having voted nay. Senate Joint Resolution 2 has passed second reading. Please be in order. Mr. Majority Leader.
Mr. President, I move the committee rise and report.
You've heard the motion of Senator Fitzpatrick. All those in favor say aye.
Wow. Well, you have been watching the Montana Senate debate our Article 5 Convention of States resolution, referred to as SJ2, sponsored by a real champion and statesman, Senator Tom McGilvery. And I am so happy to report that that final vote was 26 to 24. So by a margin of 1 vote, the Montana Senate has just approved our Convention of States resolution. That was second reading in the Montana Senate. They require 3 readings, but the third reading is really a formality. That was really the debate and the big moment. So that is our first Senate vote of the year. And of course, our first chamber passage of 2023 goes to the Montana Senate. I am just so excited. We were all on pins and needles. We weren't really sure what was going to happen there right up until the vote actually happened. We just knew that it was a razor thin margin. So congratulations to Senator McGilvery and the Montana COS team, our wonderful grassroots out there, and of course to Senior Regional Director Dave Schneider, who leads that grassroots team. I'm Rita Peters. I'm the Senior Vice President for Legislative Affairs with Convention of States Action. And I believe we are going to have Senior Regional Director Dave Schneider join us for reaction. I'm sure he is giving high fives to all of the members of our Grassroots Montana team. They were watching there in the gallery, and wow, I wish I were there with them right now. What an exciting moment. Senator Tom McGilvery has long been an amazing statesman and champion for the Convention of States movement. He, of course, introduced the resolution for this floor debate and vote there today. And Producer G, I got to tell our watchers here, my favorite moment of all was probably when Senator McGilvery took Senator Manzella up on her claim that no one could point to any evidence of the founding fathers saying that they actually had authority to draft our wonderful Constitution. So she was essentially slandering the founding fathers. And She used Robert Brown's, challenge. He had issued a challenge some time ago saying if anyone could point to a founding father saying they had authority to draft the Constitution, he would give them $10,000. And Senator McGilvery rose when he got a friendly question from another senator to see if he could meet that challenge. And he cited, I don't remember how many quotes he cited from founding fathers, but there's a whole list of them. And so I think Senator McGilvery is now owed the $10,000 prize. It'll be interesting to see if our friends at JBS actually pay up. But he called their bluff, and that was a brilliant moment. I think we are still waiting for Dave Schneider to join us. Hopefully he'll be on in just a second. I'll share my second favorite moment of the debate today is when the senator, and I didn't catch his name, sorry for that, but one of the senators rose and said, some of you talk about how wonderful the Constitution is, but you act like it's so fragile, that it's like the china at your grandmother's house that nobody's ever allowed to use. He said, our Constitution is not that fragile. He was so right about that. Article 5's Convention of the States process is there because the founding fathers knew that we would need it one day, knew that the states would need to have that power to check the federal government, to rein in the federal government when it became abusive and overbearing. And so they gave the Convention of States process to the states for such a time as this. And the founding fathers, I think, would be very disappointed that we haven't used it yet. So the Montana Senate, pleased to say by a vote of 26 to 24, has approved of our resolution, which will soon be heading over to the Montana House. And stay tuned. I can't wait to see what happens there. Also, stay tuned quite literally, because in just a short time, we'll be bringing you our third special edition of COS Live for today from the Virginia House of Delegates. In Richmond, the Virginia House of Delegates Rules Committee is scheduled to consider our resolution there. That meeting starts in just a few minutes at 5:15 p.m. Eastern Time. Not sure how many bills are on the agenda before they get to us, but we do have Senator Rick Santorum standing by to give virtual testimony for that committee hearing. So you'll want to tune in again soon and catch our live stream of that meeting. We'll probably be coming back to you live in, maybe 10 minutes or so. So look forward to seeing you again. Thanks.